Pardon me? It's 6:30, so we're going to go ahead and get started. I think I know everyone here, but if you don't know me, my name is John Lindsay. I'm one of the Stephen ministers. For our program tonight, we're going to be talking about how to pre-plan our own funerals, and also then a lot of the laws and regulations and the best things that we can look out for to make it easier for those we leave behind. To do that, we have two speakers tonight, actually three, from the Andrews Mortuary and Crematory. Did I say that right? Okay. Scott Andrews is here, and his assistant, Lori Taylor. They will be splitting the duties and talking to us about the things we need to do. By way of introduction, Scott represents the Andrews business. They've been in business since 1850. So we have a lot of experience and a lot of expressed care and concern for the people here in Wilmington. They offer a full range of services, which they will explain tonight as necessary. And there are 4 locations here in the Wilmington area, 2 in Wilmington itself and 2 in Hempstead, if I'm correct. Beg your pardon? Just one. Okay, I'm sorry. So, following Scott and Lori's presentation, we'll have time for questions. And of course, you would be free to contact them at some future time if you need to know more or have particular issues you would like to deal with. Following Scott and Lori, we have Kara Gansman, who is an elder care estate attorney from the firm of Cranville Summer. Kara has been in elder law and estate planning since she graduated. She went to UNCW, and Kara, correct me if I'm wrong, you also got some advanced degrees at University of North Dakota. Kara is in charge of a team at her particular firm and has done this for a while. She has particular experience with some of our congregation members already. So she comes highly recommended and praised by those people who have had her as their attorney. She has many published articles, and she contributes regularly to the Greater Wilmington Business Journal, offering insights. So, to get the program rolling, let me invite Scott and Lori, and I will turn the program over them to you.
Good evening. My name is Chris Hall, and I'm a Stephen minister here at St. Matthew's. I have a story to tell about my then 8-year-old daughter. Many years have passed, but some memories are too precious to ever forget. Because tomorrow is Ash Wednesday and Lent starts, it seemed appropriate to share it with you. The Sunday before Ash Wednesday, my daughter was in her Sunday school class. The lesson the teacher taught was about Christians vowing to make a sacrifice as Christ made the ultimate sacrifice for us and died on the cross. By giving up something they would miss for 6 weeks of Lent. On our way home from church that morning, she told us, her dad's sister and myself, about her class, and she said she wanted to give something up. I told her it couldn't be something she didn't like, but something she would really miss not having for 42 days. She said she had been thinking about it and had decided to give up gum. This may seem trivial, but she really loved gum, bubble gum being her favorite. I must admit, I didn't have a lot of faith that she could go without any gum that long, but I told her I thought it was a good sacrifice for her. Well, as the weeks went by, she would at times mention the fact that she sure missed gum and asked, how soon is it going to be Easter? But as the rest of the weeks went on, Easter came, and she had made it. She had had no gum for 6 weeks. I was so proud of her. That morning, when she got her Easter basket, there was gum in it. Later that day, I asked her if she thought she had learned anything by not giving up. She said, well, I guess I learned that I love Jesus more than I love gum. Have you ever given up something for Lent? Maybe it's chocolate, desserts, or coffee. Even more challenging could be smoking or alcohol. This practice is a means of abstaining from an indulgence or pleasure to better focus on prayer and meditation on God's Word. Giving up something during Lent can be powerful and meaningful. Paul, in his letter to the Ephesians, shares additional items to give up, not only during Lent, but throughout life. Examples are corrupt talk, bitterness, anger, slander, and grieving the Holy Spirit through our words and actions. Remembering that God in Christ forgave us, we are encouraged instead to show kindness, to be tender-hearted, and to offer forgiveness. During this Lenten season, may we, through the power of the Holy Spirit, be imitators of God as his beloved children, and walk in love. Because of what he gave up on our behalf, we are forgiven all our sin and able to make sacrifices in others' behalf in acts of love and service. Let us pray. Dear Father in heaven, open our eyes to the sacrifices we can make for you as we daily walk in love on your behalf. In Jesus' name and for his sake, we ask this. Amen.
Good evening, everyone. John, thank you for such a nice introduction. And again, my name is Scott Andrews. I'm with Andrews Mortuary. This is Lori Taylor. And it is our privilege to be here with you tonight. We appreciate the opportunity to come out and share our experience and our knowledge and anything else that we can share with you, as opposed to, other sources of information. We just feel like we have an advantage of being able to give you the best information that you can possibly get, more accurate than anywhere else. So we thank you for the opportunity. As John mentioned, I am a third generation of the Andrews family. Our business started in 1850, and my grandfather purchased the business in the early 20s and changed the name to Andrews at that point. And so it's been Andrews Mortuary ever since probably 1922 or 1923. So, anyway, we do have a little bit of time here in the Wilmington area and have been privileged to serve many, many families over that time. We are going to be here for a little while tonight and can answer a lot of questions as opposed to just standing up here and giving you information that you may be interested in or may not be interested in. Maybe questions would even be better. But before we get to the question part of it, I'm going to let Lori sort of tell you about pre-planning. This is what Lori has been doing for us for about 28 years. She does this every day. She is very familiar with the reasons people want to come in and pre-plan. She's very familiar with the process of pre-planning, and so she can talk to you about advantages and reasons why maybe everybody ought to at least consider it. And so I'm going to let Lori speak to you a few minutes, and then we'll answer any kind of questions that you all have.
Good evening, everybody. First off, I want to thank all of you for coming. I know funerals isn't a subject that any of us like to think about, but we need to. And I think pre-planning is what we're primarily going to talk about tonight, and that's making sure that everything's in order for your family. And I know in listening to the last seminar that you had, Pastor was very proactive about encouraging you to pre-plan, and he had some good ideas, and the church has information that you can get on file here, pre-plan, get your wishes in order. What I wanted to do, and what I found is very helpful, I think a sheet has been passed out to everyone. In doing presentations and in talking with people every day, doing pre-planning and being in the funeral home, the same questions seem to come up over and over again. So I thought to get things started, today I jotted down 10 of the most frequently asked questions of me when folks are pre-planning or at the funeral home for a service. And I'm going to just go through these, number 1 through 10. If we get in a time crunch and there's one that you see we're not going to get to, just stop me and yell out the number of the question, and I'll address it in between Scott and I. I think we'll be able to answer questions and hopefully put your mind at ease that it's a very good thing to do to pre-plan. So in starting with, everybody get a handout sheet? Okay. In starting with question number 1, how do I pre-plan my funeral? Sounds pretty simple, but a lot of folks don't know where to begin. And pre-planning your funeral, you can do that in several places. Like Pastor suggested here, you can get the sheet that he passed out, fill out the information and get it on file. You can come to the funeral home and pre-plan. And what we do is we gather all the information that is going to be necessary at the time of death for basically 3 big areas. One is for the death certificate. It's the funeral home's responsibility to create a death certificate, fill in all the information. We route it to the doctor who fills in the cause of death. And then we take it downtown to the Register of Deeds where it becomes certified, and we can eventually get your certified copies. Those are necessary if any of you have ever been involved in estates for processing life insurance, stocks, bonds, selling of a car. Someone told me they needed one to give to the cable company to get the cable turned off. So some things are surprises. They're $10 a piece. So we gather all that information so that at the time, none of that changes. So at the time of death, we can fill in the death certificate completely. Family proofs it, and then we get it en route. Information are things like birthday, social security, mother's name, mother's maiden name, father's name, years of schooling, your occupation, things like that. That's the one area. The second area is an obituary. Most people want an obituary either in a local paper, an out-of-state, out-of-town paper, or on the website. So we can go ahead and get that information. And that's one thing that I really encourage people to do, even if it's just make bullet points of what you would want in your obituary. Trust me, kids or family members would not come up with the same list that you come up with for your obituary. Many times, kids especially don't know names of groups that were important to you or accomplishments, or at the time of grief, they forget something, so it's very important to get that documented. And the third thing is the obvious, and that's what type of funeral service you want to have. Traditional, cremation, where you want your service, and then selecting the merchandise. Whether it's cremation or traditional funeral service, there's merchandise to be selected. And you can go ahead and select that, and we document it. So everything is in a file, and instead of a family coming in tired, upset, grieving, in an area of their life that they've never been before, and trying to answer many questions and make decisions, it's all before them, and we just kind of walk them through it. Nothing is worse as a funeral director than to sit down with a family and they don't have a clue what their loved one wanted. So it is a loving thing that you can do. Number two is can I lock in the cost of the service and merchandise I select? Yes, you don't have to. Getting the pre-arrangements on file at the funeral home is one thing. Everybody should do that. It doesn't cost a penny. The second part, before you leave that conference, you can get a cost estimate telling you what the funeral that you selected along with merchandise costs at today's price. Should you decide at that point or in the future to lock in those prices and guarantee services and merchandise, you can prepay. The contract is an inflation-proof contract, and it states that on it. Everything is itemized out so that at the time of death, what you've selected is paid in full, even if you live to be 110. So that's something to do. Rule of thumb, about every 17 years, prices double. So you can kind of calculate out to the future. Number three, what if I prepay and pre-plan and then move? A lot of people ask that. You can let us know. We'll forward all of the information that we have to a funeral home in the new town where you move. And if you've prepaid, those funds are then available to that funeral home. So you don't lose anything. Number four is, a lot of people say, well, I have life insurance or savings. Isn't that good enough? Sure, it's great. Just make sure that that life insurance policy keeps up with the price of the funeral that you've selected. If you've prearranged, call the funeral home every 5 or 6 years and say, hey, pull my file and tell me what the current cost is of the funeral. Compare it with your life insurance. One thing to be cautious of is if you go into a healthcare facility, assisted living, and your funds start going down rapidly, you don't want to leave your family with the cost of the funeral that you've selected because your funds have been depleted. Number five, what if I live here and wish to be buried in another state? Many people, most of us, I guess, aren't from Wilmington. They're from somewhere else. So the casket, if it's a casket burial, would have to be transferred to another funeral home out of state. And we do that weekly, just about.
We do that very frequently.
Yeah. And with that, maybe Scott can tell you kind of how that works, because he's more on that side of it, and the casket is purchased here, and then...
Yeah, and so then, depending on the location, the destination, how far transfer would be depends on if we use ground transportation or air transportation. In our mind, we think about 350 miles is kind of the cutoff or the break even. So anything less than 350 in mileage, we would use ground transportation, and anything around 350 miles and further would be air transportation. But it is, like Lori said, it's something we do on a weekly basis.
All right, number 6, what are my options for a funeral service if I choose cremation? There's many, many options, but narrowing it down, I can kind of summarize it into 3 different options. The first one is just cremation. So as far as the funeral home is concerned, the cremation process is taken care of, the death certificates are handled, any newspaper notices, and after the cremation, the ashes are returned to the family. Number 2 is if we cremate and then the family wants to have a memorial service either at the funeral home or here at the church or at the grave site. Some people even do it at the clubhouse or a special place. And the third one is kind of still being in the traditional funeral mode where there's a casket present, there can be a viewing, a visitation. At the funeral service, the casket is present. And then following the service, instead of everyone proceeding to a cemetery, the cremation takes place and the family receives the ashes in a day or 2 after that. So there's a wide variety depending on what you want to do and what your family needs are for the visitation and service. Number 7 is how much does Social Security pay at death? A whopping $255. And that's only to a surviving spouse. It's what it was years ago. They've never changed it. It used to pay for a good portion of the funeral. Now it won't even buy flowers, but that is paid to a surviving spouse. The next one is, are outer burial containers or vaults required for a casket burial? And Scott, do you want to address the vault situation?
There are no state laws or federal laws that require an outer burial container or a vault. That is up to the individual cemetery that may have their own rules in place. And the reason they do that, the reason the cemeteries do that is to maintain the integrity of the grave. Most of the vaults are made out of concrete. Some are made out of steel. And they, like I said, they are required. It's a local cemetery policy just to help maintain the integrity of the grave and also the aesthetics of the cemetery. If you didn't have a product like that, over time, the ground would sink in and be unlevel, and so it also does reduce maintenance. So that's the reason cemeteries require them, but there are no laws that require them.
What benefits am I entitled to if I'm a veteran? Are there any veterans out here? Okay, good. Yeah, thanks, guys. And are there any female veterans? Okay. As a veteran, if you have your DD-214 or your discharge paper and present it to the funeral home can obtain a flag. It can be folded in a triangle and presented to the family. We can have the military come, fold it, and present it. If it's a casket burial, the flag can be draped on the casket. If it's cremation, it's usually in the triangle. The military can fold it, present it, play taps. Veterans are also entitled to burial in a national or state cemetery. Unfortunately, the national cemetery here is full and has been for years. The closest state veteran cemetery is in Jacksonville. And what veterans are entitled to there, veterans and a spouse are entitled to a space or a niche or ground burial of cremated remains. They're entitled to the marker or the headstone for both the veteran and the spouse. And the veteran does not pay for opening and closing of the grave, the digging of the grave, but the spouse does. You do, in a state veteran cemetery, you do have to purchase your own vault. In a national cemetery, Most of them will provide a grave liner or a basic vault for you. The last one, and then we'll open it up and Scott and I can answer any additional questions you have, is what can I do to make my funeral more of a celebration of life? And there are so many things that one can do. There are pictures, I call them happy memories, that you can have of the individual or yourself at events, weddings, with grandchildren, being funny, that when people see them, it makes them laugh and remember those happy times. You can choose your own music. If you have favorite hymns, if you're like me, if you sit in church and you'll say, oh, that hymn, I love that hymn, it's my favorite one, jot it down. Nothing is more personal for the family when the service is going on than when the hymn plays or the song plays and they know it's one that the individual that they loved selected. Same thing with scripture, a poem, a verse, anything along those lines. It just makes it a lot more meaningful than kind of a cookie cutter type service if it's more personalized. And it should be more of a celebration of the individual's life. So the last thing on here that I wrote down here is funeral pre-planning is one of the most loving things that you can do for yourself, for your spouse, for your children, for your family. So with that, any questions for us?
Now, one other thing.
Yes.
As far as pre-planning, I think, in addition to what she just said, by you making your wishes known, you're going to get what you want. If you don't make your wishes known, if you don't share that either with a funeral provider or with your family, when you leave, your family is just going to be wondering, I wonder what he wanted, what he or she would have wanted. And they're left guessing, and they're having to make all kinds of difficult decisions. So it's a very thoughtful and loving thing to do to, at the very least, make your wishes known to someone, whether it be a family member or a funeral provider. So, I think in addition to that, obviously there's a financial part of it too. But I think aside from the financial part, I think the biggest thing is just taking the burden off of your family having to make decisions on your behalf. So I think it's just a very good thing to consider. So with that said, we'll open it up to any questions. Yes?
On number 6, where you mentioned you could have a casket at the service and then cremate afterwards, is that a closed casket, or is there embalming done if you wanted to have an open casket service and then cremate afterwards?
Yeah, that's a great question. So some religions prefer to have the body present for a church service. Some family members prefer to have the body present for a church service or even a chapel service or a visitation. So the body can be embalmed, prepared, and you can have an open casket for any of those events that I just mentioned. Then, instead of going to the cemetery, then we would go to the crematory for cremation. So you can have all the benefits of a full traditional service, and then, like I said, you don't have the cemetery expenses or anything like that, and then you can be followed up by cremation.
And the other thing with that too, embalming is not required by law. We highly recommend it when there's going to be a viewing for obvious reasons, but it is not a requirement by the law.
I've had a number of clients who are asking me about green burial options around here, and I'm only slightly familiar with them. What do you all know about those? Is that something you all offer?
Well, to be perfectly honest, they are not really available in this area. don't know a whole lot about them. The closest green burial cemetery that I'm familiar with is somewhere in South Carolina. And talking to colleagues around the country, while it's a great idea, don't do it expecting to save money, because it's actually more expensive to do the green burial service than it is just a traditional service or cremation service. But unfortunately, I do not have a lot of information or details about that, simply because we just don't have, there's no place around here to do it.
Does Andrews own their own cemeteries?
Yes. As John mentioned, we have 3 locations. The location in Hampstead also has a cemetery right beside the funeral home.
And what's your availability right now, like for space? I mean, are you filling up? Or
There's always room. Up at our cemetery in Hampstead, we have about 18 acres dedicated for cemetery property, cemetery space, and approximately half of that is developed at this point. So we do have room to expand when we feel like it's necessary.
and you also do burials like in Oleander and
Anywhere.
Greenlawn?
Yeah, anywhere.
How are they fixed for space, do you know?
I can't quote any numbers in terms of availability, but I do think right now there's plenty of spaces.
Okay, thank you.
Yeah, you're welcome. All right.
Thank you very much.
Thank you all very much for your time. Okay.
I want to thank you for having me tonight. My name is Kara Gansman. I'm an elder law attorney here in Wilmington, and I do have great experiences with Andrew's Mortuary and Funeral. They handled my mother's funeral, did a wonderful job. I know that my family never felt more peace of mind with how they've handled everything. It was a really wonderful and very caring experience. We used the Pine Valley Chapel, and I can't say enough good things about working with them, especially at a time of grief. And I think one particular note, no matter how much you pre-plan, there are still things that you can't, that your family members will be surprised at, such as where you might have kept your door key, or there are things that your family members will want to know before you've passed away. And doing so much of the pre-planning can be so helpful in helping your family members help you when you're not here to further your goals and your plans. So as part of that pre-planning, it is a very loving act. As part of the work I do as an elder law and estate planning attorney, that's where we put a lot of those mechanisms into place for pre-planning to bring you that peace of mind, but also to bring that plan to your family members or your loved ones so that they are able to continue to fulfill your wishes. As part of a pre-planning, a lot of times people automatically skip to when I die and what do I need, and we need a will or we have a will. And I think that, in my mind, is one piece of a pre-planning need. And that's certainly a helpful piece in allowing you to identify your wishes for where you want your assets to pass and how you want them to pass and who gets them and how much and when do they get those things. And those are incredibly helpful, and those are fulfilling your wishes. A will is a document that would allow you to do that. There's two other documents that in my mind are probably more important for pre-planning and probably just as important, or should be just as important to you, but equally important to your family members. In my mind, these are two documents called powers of attorney. One is for health and one is for finances. And those, in my mind, are the most important documents that someone would need as part of a pre-plan. And it's really because those two documents alone are effective in your lifetime. And this allows you to identify who can help you when you're not able to make those choices for yourself. So if you were unable to make healthcare choices for yourself, this allows you to appoint someone called an agent who would be able to make those healthcare decisions. And these decisions could run the gamut from being able to make emergency medical decisions if you're under anesthesia and can't tell the doctor, please continue the exploratory surgery or remove the tumor that he found in this exploratory surgery, to other things, such as if you have advanced dementia and you're no longer able to make those safety choices for yourself and your health. Having someone else that you trust to stand in your shoes and make those suggestions to your medical providers is helpful. A healthcare power of attorney is helpful in guiding your doctors through your end-of-life wishes and authorizing the withdrawing of life support or life-prolonging care and life-prolonging measures. That can be incredibly helpful, especially for your family members. That's what we call living will. It's part of a component of that healthcare power of attorney. And that's where, like Lori had mentioned, your family members don't want to second guess what they are doing on your behalf, especially if they don't have the opportunity to speak with you. So a living will is an opportunity for you to tell your family, if I'm in a permanent vegetative state, I wouldn't want to be kept alive artificially, or I wouldn't want to be left on life support. And this is helping your loved ones work through a grief process before you're gone in deciding that this would have been what you wanted. This is an instruction to them from you. And so that's another piece of that pre-plan that is a very loving act, that they won't be left to wonder, are they doing the right thing? The other piece of that healthcare power of attorney, and this is helpful in following Lori's conversation, is that after you've passed, the funeral home needs someone that they're going to look for guidance. And often it's that healthcare agent under a power of attorney who they will look to as having that legal authority. In many cases, without that document, they're left to look to different family members, which is wonderful when your whole family agrees. But if your family doesn't agree or there's conflict, it puts people like Lori in a difficult position to negotiate between different factions within your family who believe you wanted one thing or another. And again, avoiding that kind of conflict is what a legal document can do. So healthcare power of attorney, where you're appointing those people to make those choices, and identifying those choices is critical. That other power of attorney that I was thinking about too is a financial power of attorney. This is one where, again, you identify an agent or a person to make financial or transactions for you or financial decisions for you. Sometimes this is if you can't, and often it's out of convenience, even if you could, but you don't want to. And I'll use my husband and myself as an example. We have a power of attorney for finances where we've appointed each other as an agent. He happened to sell one of our vehicles not too long ago. I was at work, and he went down to the DMV to turn our plates in. And the DMV needed him to sign on my behalf as my power of attorney. And it was very convenient for me. I didn't have to go to the DMV. It wasn't that convenient for him because he forgot my power of attorney at home and had to make 2 trips. But that was the document that gave him the authority to sign for me, so that I didn't have to appear and show. I was perfectly capable of doing it, but out of convenience, he did. There are times that you may want to restrict your agent from acting on your behalf under this document, and it's partly because sometimes people don't need to have that much access to your stuff. And I'll use my own situation as a good example. My husband and I don't have those restrictions on each other, but if something were to happen to my husband, I've named my brother as a backup agent. I trust him to do a good job, but he doesn't need to have that kind of access to my assets, at least not while I'm still capable of managing my own affairs. And so there are times that you may want to put restrictions on people, and in my brother's case, he wouldn't be able to handle my assets unless, first, my husband's not here, and second, if my doctor says I'm not able to handle my finances very well. And that's a nice way of having someone reserved to step in when I needed it or when I might need it, but it certainly doesn't allow my brother to look at my bank accounts or look at, whatever I've got or access that or do any transactions. And so it's a nice way of protecting me. It's also a nice way of protecting my brother. He doesn't want that job right now. He's got his own problems. And so it's nice to know that he's willing to step in, but he knows that I don't need him to step in. And so there are things as you're crafting that document, you may want to plan and think about who's going to be my power of attorney, when do I want them to be able to act for me, under what restrictions would I place that person when they're acting. In that financial power of attorney, you probably also want to think about all the things that you would want them to do and maybe things that we could want them to do. And that's a little bit of the distinction between estate planning and elder law. In general terms, we want people to be able to engage in real estate transactions on your behalf or handle your property, like your belongings, your household items. We may want them to be able to access bank accounts or insurance plans or retirement accounts or pay your taxes. These are all things that truly are basic items that are necessary for you to continue living or sometimes fulfilling certain obligations. There are also times that as an elder law attorney and in terms of pre-planning for long-term care, that we may want to build in certain provisions that, in my mind, offer asset protection and the ability to protect your assets if you ever needed nursing home care or you were looking to other benefits like veterans benefits for long-term care or Medicaid benefits for long-term care. There are provisions that you can build into your financial power of attorney that allow you to divert your assets in a way that could be protected so that you can accelerate your eligibility for some of these public benefits without having to spend everything you own on nursing home care and then qualifying for benefits. These are options that aren't in every power of attorney. It really depends who you're working with on whether these are options that are necessary for you or your needs or whether that's something you would want. And certainly up to the attorney that you work with if that's something that they would understand what you're looking to do. But these are specialized provisions that can be very helpful in protecting assets like your home. If you ever needed nursing home care, we might want to protect your home. Or if there's a spouse who needs nursing home care, but one spouse doesn't, we may want to divert assets to the other spouse so that they can protect and live within their customized standard of living, as opposed to slowly dwindling down the couple's finances. So those are things that you might want to look at and think about as you're crafting a financial power of attorney, because a more basic power of attorney wouldn't have these permissions in place. It certainly requires a lot of thought and conversation on the person who's crafting that and whether that's necessary for your needs. Often people will ask me, well, what if we don't have these documents? What if we wanted to pre-plan and we always put it off and always put it off? And I'm one of those people. I do this as a living, but like the cobbler's kids who don't have shoes, I didn't have an estate plan for probably 10 years. And really, if I said I just got one a couple of years ago, that's the honest truth. Knowing that I have an 11-year-old at home, I'm better giving advice and following my own advice sometimes. But if you don't have these two powers of attorney, all is not lost. You can still have a court-appointed guardian to do many of these same, or makes many of these same decisions. It's not preferable to have a guardianship in place, mostly because it's requiring a court process to reach that point. It requires your business to be laid out in court and have a judge appoint people. Sometimes that judge may not appoint the people you would have appointed, and certainly it's a public proceeding in many cases, and that can be a more private matter that you could avoid by having a set of documents on your own. In terms of whether you have documents from out of state, that's a big question I get asked very frequently with so many people moving here from other states. If you have documents from out of state, like these two powers of attorney, The healthcare power of attorney is very specific to each state where you were executed that. Every state defines certain aspects in their own, using their own words or their own language, and it's often, we may say the same things that we may say in Virginia here in North Carolina, but the words are just different enough that it's often advised, just have this looked at by somebody here in North Carolina, see if this is acceptable language. I will often review these documents with clients, and I review the powers of attorney for a couple of things. Are these still the agents that you would want in these roles? And that's usually the case in many cases. And then I like to review the documents to see, does that document refer to another state's laws? And if it does, that may be something you want to avoid, because in terms of avoiding higher costs, you may not want to have to apply Virginia law to everything you're doing here in North Carolina. Not every attorney here knows all the laws in Virginia or other states, and so there are times that there may be a question that we have to look to another state's law, and that may mean we have to have another attorney from that state explain what that law is just to fulfill those duties. So often I will look to see, does that document require that we apply that state's laws versus something here in North Carolina. Who's got questions about powers of attorney before? Yes, sir. Okay.
Kara, to that point, I was power of attorney for my mother in the state of Arizona.
Okay.
Upon her death, which was July 3rd of 2020, that ended. And then I became the executor of her estate. Does that apply here?
That would be true. In most cases, and I'd like to say all, I'm sure there's a case out there that's different from that, but in most cases, a power of attorney is going to end with someone's death. And I'll say a healthcare power of attorney can be effective even after someone's death in limited ways, such as working with a funeral home or the HIPAA authorization that might be included in a power of attorney. But typically that may last just a couple of years after death. But you're very right. A power of attorney is typically most effective during someone's lifetime. Typically that would end at someone's death, and then another role takes over. That could be executor of someone's estate, or it could also be a trustee of a trust. And that's a real nice segue to the next part of the conversation, but I want to make sure I get any other questions about powers of attorney before we transition to wills or trusts. All right, so that was a really nice segue. Pre-planning with wills or pre-planning with a trust is most commonly what many people think of when they talk about planning for estate plans. And so there's really two different avenues you can plan for your estate. Having a will is most commonly known. It's a written document where you identify your wishes, where you want your assets to pass. You can also identify your executor. That's someone who has to take your will and a death certificate down to the courthouse and open up what we call a probate or an estate administration. That's usually done in the county where you've passed away. So if you're a New Hanover County resident, we go downtown, we talk to the clerk in the estates division, and we say we need to open up a probate. Here in North Carolina, in simplified terms, there's two different forms of probate. What I like to call a smaller probate, when your assets are $20,000 or less. That is an abbreviated form of probate. Typically, it can last 30 to 90 days. In some cases, it can last longer, but there's not a lot of work to be done in that. There's no notice to creditors that is run, and really, it's because the assets aren't that much in the court size. If you have assets that are $20,000 and greater, then it's a full probate, or what my team will call a large or a big probate. And that's where you're not just applying to be executor, you often will have to file a bond with the court if you have an out-of-state executor. And that bond allows the court to ensure that the estate assets would be protected during the executor's tenure in handling the estate. Often we will run a notice to creditors in the newspaper, and that allows any creditor who believes that the person who's passed away, that's called a decedent. If that decedent owes money to a creditor, we ask them to come forward and tell us what's owed. At the end of that 90-day period, anybody who comes forward after that 90 days or after that creditor's period has run, they may not get paid, and by law, the executor doesn't have to pay that person if they didn't get their claim in on time. But for any claims that are brought within that 90-day period, the executor has a chance to review them, decide whether they're valid claims. In many cases, they are. And then the executor is tasked with the requirements to pay certain creditors in the right order. And that's not too difficult if you have more money than debts, but in some cases when money or debts look about even, or there's less money and more debt, then paying the right creditors in the right order can be very important. In fact, it can create some criminal liability for the executor if they don't pay people in the right order. So that's when it's important to get help. If there's at all a question, how much money is there and how much debt is there? There are times that the executor might be forced to sell the house to make money to pay for any expenses or claims that are valid claims. And so that's where knowing when you can sell the house is especially important. I know in this area where our real estate market is incredibly fast-paced these days, people don't want to wait 90 days to sell the house, and it is our advice that they wait through that notice to creditors period because there does pose some liability to the executor for selling the home before that period has expired, and especially if there's a claim that comes due that's bigger. So those are things that we would talk about in terms of the deadlines. After the 90-day credit period has run, creditors are paid, then the will would apply to allow the estate to be distributed to the people identified in the will. This is where, coming back to the idea that Lori was talking about, that if someone didn't have enough money to pay for their funeral, right off the bat, North Carolina, the estate will pay whoever has paid for a funeral for a loved one back. So under North Carolina law, there are some limits. Typically, it's $1,500 for a funeral, but I haven't seen our clerks have a problem when someone has paid more for that, because we know funerals and cremation services can be a little more than that. But often our clerks will approve an amount greater than that when there's sufficient assets in the estate. And so that's one of the first claims that gets paid right off the top. Legal fees is another claim. And then after that, there is a spousal allowance available to a surviving spouse. It's an allowance that you have to apply for. It's been increased in the last couple of years to $60,000. It's a one-time allowance right off the top. Minor children also get a smaller allowance. I believe it's $5,000. And so that's, again, right off the top. And then everything else, after those debts are paid, then passed out to the people that you've identified in your will. And you can pass those out to people directly. So if your loved ones who are receiving an inheritance from you are financially responsible or mature enough to handle an inheritance, you can leave that money to them directly. If they're young, if they're 11 years old, like my child is, we don't want that person to handle money too much. They legally can't, and nor should they. And even if they become 18-year-olds, in the eyes of the law, they're mature enough to handle money. I think in our wisdom as adults, 18 is still pretty young to handle money. And so there may be ways that you want to protect the people that you love from themselves by holding their shares in trust and doling out money over time, perhaps for education, perhaps for health needs, and for other needs that you determine might be important to that loved one's necessary needs. And so those are things that you can identify in a will. There are times that we want to protect other people that we love, even if they are adults. These are people who might be chemically dependent on drugs or alcohol. You love them, but they shouldn't have money. Maybe they gamble. Maybe they have jobs that have some risks and liability that pose their potential to lose an inheritance. Perhaps they are on the verge of a divorce with a spouse, and so there are reasons that you may want to hold a loved one's share in trust as a way of protecting an inheritance for them. And those are things that you might want to talk about as you're crafting your estate plan. It's providing you that peace of mind, but it's also protecting the people that you love, sometimes from themselves. The different form of an estate plan, if it's not will-based, is really a form of what I call a living trust. A living trust is something that you would create during your lifetime, and you actually transfer assets to that trust during your lifetime, like your bank accounts or a home. One of the biggest benefits of having a living trust is the fact that you're avoiding probate. You don't have to go through the whole court process just to pass your assets to someone the way you want it to pass. You can avoid all the court procedures by having a trustee take over. And so that trustee is someone who steps into your shoes and still handles your assets just like you would as a trustee during your lifetime. Trust can be very beneficial in terms of not just avoiding probate, but you can name trust as beneficiaries on life insurance policies, on IRAs, and things like that. And it's a real nice way that many blended families may use trust, because it's a nice way of providing for a spouse who survives you and still being able to provide funds for kids, your own children or other people, even after your spouse is predeceased. I often will work with blended families who have just a will, but there's some conflict between a spouse and the other person's children. And I remind them that a will-based plan is great, but it can be changed. So if one spouse passes away and the surviving spouse doesn't like the other person's children, there's no guarantee that surviving spouse wouldn't change a will. That's a little different with a trust. It's a little beneficial to have a trust in place where you're able to divert funds and still provide for people, but ensure that money gets reserved for the people even after your spouse has passed. So those are things that I often will talk about with families in a blended family situation. What kinds of questions do we have on wills or trusts?
Kara, if I set up a living trust and I instruct the trust or the bank that this is the amount of money and this is how it's to be divided amongst my children, my spouse, they have no say in that, correct? The trust will execute whatever I tell them to do.
As long as it's legal, yes. But typically that would be true. If you have made an instruction, even if it's silly in everyone else's eyes, it's your wishes, and as long as it's legal, the trustee is obligated to follow your wishes in administering the trust.
Unrelated to that, and I apologize for going back to Arizona.
It's fine.
To prepay my mother's funeral costs, Arizona required a life insurance policy. Mm-hmm. It locked in the price with the funeral home, but in the event that they went out of business, that life insurance was mom's to be taken elsewhere. Does that exist in North Carolina?
That's probably a better question for Lori than me. I'm presuming that would exist, but Lori is my expert on that.
Yes, the law in North Carolina is set up when you prepay to protect you, the customer. Funeral homes have to place the money with an insurance company to hold until the time the funeral is provided, and then they release it back to the funeral home.
It sounds to me that your business might be something that a surviving spouse would want to come to you and go over all these things to make sure how it's going to all develop, rather than, well, it's just going to be cut and dried from a will and so forth. You would go over everything, all these possibilities for them. Is that correct?
I think I'm following you that yes, pre-planning is good, and even pre-planning before your spouse dies is better.
Right, but you
But
do
that
all-
is something that we do. We work in the, before people pass away, in planning through the legal documents, through the powers of attorney, crafting wills or trusts. And then even if someone's passed away, we do assist with the probate or the trust administration. In either case, every step of the way, we're happy to meet with families and guide them through whatever point they're in. And every situation is so different. And just when you think you've seen every situation out there, someone like the other day came to us with a very unique situation, and it feels a lot like a bar exam, because every hard scenario is present in this one case, and it's exciting to try all of that out all at once, as hard as it might be.
And along a similar line, if one spouse is very technical oriented and the other one isn't, and the surviving spouse is the one that's not so technical oriented and wants to close out various automatic payments and various things that are set up to go on and needs help to do that, are you, or do you know of people that are able to help that person rather than trying to call a relative that might be an expert in computers or whatever?
No, I think that's something that we can assist with. If those accounts are being held with any kind of financial advising company, we may often connect them with someone there who knows those accounts better than I would, and just kind of walking them through, this is the person you might want to contact. When we can reach out to banks on people's behalf, especially to stop automatic payments, and especially in an estate situation, we can and we will. And part of that process is somewhat educational for the surviving spouse in getting reset up and how to do bill pay in the way that makes sense to them, especially if they're not tech savvy. If they want to write checks all day long, then going back to a more receiving paper statements and not receiving the automated withdrawals can be more helpful for people who are a little more paper oriented, and I'm becoming more like that myself. I like seeing things on paper because I can save it and store it, and I can look back at it versus an email that disappears after I delete it. So we're happy to help spouses kind of get reset up in a way that makes sense for them.
Thank you.
Hello, how you doing? My question involves what typically goes into a trust. I know you mentioned real estate, probably life insurance. What about savings accounts?
So that's a great question. Being able to fund your trust is really important. In terms of avoiding probate, you can only avoid probate if you have funded your trust with your assets. So typically what would go into a trust, and at this juncture I'm talking about a revocable living trust, one that you're in charge as your own trustee, that you are also the beneficiary of, at least during your lifetime. We would want to fund that with real estate. So any real estate that you may own in your name, cash accounts of all kinds, so checking, savings, stocks and bonds can go in there, investment accounts can go in there. I don't put qualified or tax-deferred accounts like IRAs or 401ks in a trust, not while you're alive. We can name a trust as a beneficiary for those assets, though. And the reason behind that is that otherwise we would be liquidating the account and having to pay taxes on that. You can put life insurance policies into the name of the trust, or similarly to a tax-deferred account, you can name the trust as a beneficiary as well.
Okay, so that involves retitling the property?
That's
so
right.
Instead of having your kids, let's say, as beneficiaries, you retitle them the trust?
You may want to name the trust in lieu of your kids, and that's especially helpful if you have young people. That if your kids are minors, you know they're not going to be able to inherit from you right away, that you know you're going to hold their shares in trust anyway. So just naming your trust in lieu of the children that you might name otherwise can be very helpful.
Okay, so all that stuff that's in the trust avoids in the perfect world, I guess.
In the perfect
That
world.
avoids probate. So what about all the stuff that you forgot? I mean, what if you have like, let's say artwork or jewelry? How do you put that kind of stuff in a
So
trust?
that's what we typically call tangible personal property. And for lack of a better word, it is stuff. Some of that stuff has, some of it has titles. Like some artwork has a title to it. Most of the time, at least the stuff I own, I don't have a lot of title on my art, or my forks or my furniture, but it's still my stuff. And technically, to avoid probate with that stuff, we would do an assignment, it's a very general assignment, but you're saying all the interest in the stuff that I own, sporting goods, my books, my any jewelry, any tools, these are all things that I'm assigning now to my trust, and that is usually what's accomplishing that funding of the trust with the things that don't have titles. I don't like to recommend putting vehicles into the name of the trust. And I think that's a personal determination that each attorney would make. I know some attorneys here in North Carolina do, and I don't think that's the wrong choice. It's just not the advice that I give. Partly because in order to fund the trust with a vehicle, you have to retitle it. And part of our process here in North Carolina, to retitle a vehicle, you have to pay the taxes all over again and the registration fees. And that, in my mind, seems a little much. On top of the fact, it's my perception that our liability laws here in North Carolina would potentially put the trust assets more at play after an accident, especially if it was one that someone accused you of creating. So I typically don't want to make the trust that available. That's not to say that a revocable trust protects your assets like that, but I just don't want to make it that easy for someone to sue you and get to the trust assets so quickly.
Thank you.
Kara, within the last couple years, a non-spouse who inherits an IRA or 401k has to withdraw all that money within 10 years.
That's right.
When a trust is named as the beneficiary, does the trust fall under the same rule? Because we have a
So,
client at work that did that.
You're referring to the Secure Act, which came about in 2019, right before COVID. The Secure Act was a big deal, and then COVID hit, and nobody remembers the Secure Act until something like this happens. And what you're referring to are these rules under the Secure Act. There are certain designated beneficiaries who, under the Secure Act, still can receive lifetime status. That's typically a surviving spouse. So they're not limited to having to withdraw that account over just 10 years. A disabled person, I think it's a disabled child even, of any age, does not have to draw down that account within 10 years. And a minor child also does not have to draw that account down over just 10 years. Instead, under the Secure Act, they have to wait until age majority, 18, and then they have 10 years. But everyone else, and that's where I'm going to say trusts included, and they do have the 10, and there's still some questions too under the IRS rules. There's some opinions that are still coming out even a couple of years later. Sometimes it's a 5-year look back still or drawdown, but for most it's 10 years. And so some of the thoughts, well, the whole intent behind the Secure Act is to minimize taxes as people go, but there's no requirement under the Secure Act to draw down once every each of the 10 years. And so right now, some people are saying, well, what if I just wait till the end of that 10-year period and then I'll pay the taxes? I think we're all kind of left to wonder how the IRS is going to tighten those rules up. But I don't know if I really answered your question.
Well, yeah, we've got a client at my office that named his trust as beneficiary of his IRA. And the trustee was in the other day and we're like, you know what? I'm not sure if do you start taking money out of that? Are you subject to the 10-year rule or not?
I think
So I guess I'll go back and,
if the trust named, and this is where the details get really thick. I just watched a continuing ed course on this the other day. If the trust named a single beneficiary, then it's easier to say that under some of these exceptions, it can still last longer. But I think typically under the general rule, under the Secure Act, I say 10 years.
Okay.
And there's always more to the story than
Yeah.
that. So I always like to read on it, but it's
Okay.
something I'm still learning.
thank you.
I think there's one last topic I want to touch on just a little bit because it's important to me as a pre-planner, and it's really the heart of what I do as an elder law attorney, and that's really pre-planning for long-term care. That's a stage in some people's lives that it's difficult to plan on, and some of that foundational ability to pre-plan rests solely in that financial power of attorney. But it also involves having some of these other documents like that healthcare power of attorney in place. But pre-planning for long-term care means protecting not just maybe a surviving spouse, it could be pre-planning to leave a legacy to your family members if that's what you want. Pre-planning for long-term care means that you may not want to spend everything you own down on nursing home care for you or a spouse. And so pre-planning takes various different forms. Sometimes it's purchasing a long-term care insurance policy. I don't sell those, but often people who have financial advisors can work with that advisor in finding a policy that would meet their needs. That is certainly a loving gesture that you can offer your family in being able to provide for your own care needs without spending your own money down. As an elder law attorney, that's a tool that I like to use as planning, knowing that that's money that can be paying for care needs, all the while if we want to protect money for your spouse or your children or other loved ones in different ways, like pre-planning with an irrevocable trust. That may be something that we would want to talk about. There are different, for the veterans here, if you are an active duty veteran, you and your, and that's during a wartime period, you and your spouse could be eligible for a certain special pension from the VA. It's called Aid in Attendance. This is it won't pay for all of your long-term care costs, but it certainly can pay for some. And it's a wonderful tool that we like to use for our veterans and their spouses in planning for long-term care. It's not something you're automatically eligible for. You do have to apply and qualify for it. The VA Aid in Attendance has what we call a 3-year look-back period. So if you are applying for those benefits, typically under that rule, you can't have made a gift of significance in the 3 years before applying for that VA special pension. And of course, even if you're not a veteran, Medicaid is an available public benefit that we often will look to pay for long-term care costs. And sometimes our pre-planning means we are accelerating your eligibility for some of these benefits. And you may pay privately for some of that care with the goal of qualifying for those benefits a little sooner or having a long-term care policy in place to help cover that. One of the things that we do is in crisis planning, when we are looking to qualify someone for Medicaid in particular, is that we will instruct them to go to Andrews, go purchase your prepaid irrevocable burial or cremation plan or policy. That's something that Medicaid permits people to spend money on, and we certainly want them to have a plan in place and have that paid for instead of looking to their family members for paying for those services. So those are things that we would counsel people on in learning to preserve their assets or otherwise qualify for benefits. And that's certainly a big part of what I do as an elder law attorney, and it's certainly something that for pre-planning can be important to you all or your loved ones. Do we have any questions on long-term care planning?
Well, I thank you all so much. I appreciate it.